Hey, chat. So we are back for the afternoon part of Karen Reed. It's going to be the charging conference, which is going to be like uh watching paint dry. So we will see what happens at that time. Certainly they're going to make a motion to dismiss. That's not going to go anywhere. I mean, we've already mentioned these before. Nothing's going to happen. Aunt Bev is going to be a dumbass. She's not going to allow it. But yes, we've all seen this, and we're like, wait, this is the best the state can do. This is the best they can do. Yeah, yeah. Sadly, this is the best the state of Massachusetts, the Commonwealth, could put together. It's absolute travesty. This woman's having to fight for her life and deal with this. I do get the feeling we are going to have to watch on Long Cuck because I don't see anything up yet on the channel we've been watching the whole time. We'll keep track though because there's got to be some other places for us to try because I don't want to go back. Don't want to go back to Long Cuck chat. That would be awful. It'll be enough the jury's look convicting with no evidence. Oh yeah, no. There's more than enough evidence for a jury full of retards and just overall schmucks to convict Karen Reed. And that's the sad thing. There's more than enough evidence there. Entirely more than enough. I think if the state loses, they should have to foot the defense fund. That state would be far more careful. Oh, I think so. So Green Cap says, what's a charging conference? Charging conference is where they go through the jury instructions page by page by page and make sure they're all agreed. They've hammered out all the issues. If there's underlying motions as far as like objections, stuff like that, all that would happen. But for right now, it's kind of just they'll be clearing up everything. If the state wants to try a lesser included, they might ask for it at this time. We'll see. I don't know if that's even been thought of or if the state has already pretty much included the lesser included. I would argue they have at this point. Is she charged of first degree murder? No, second degree murder. Second degree murder. As far as the 1983 lawsuit, guys, no. Prosecutors have prosecutorial immunity, and the courts have judicial immunity. And prosecutorial immunity is pretty much bulletproof. Like, if you think that qualified immunity was bad, prosecutorial immunity is basically like you can do whatever the hell you want, and you're not responsible. So, yeah, nothing's gonna happen. Nothing's gonna happen to anybody. Lally's fine. Aunt Bev is fine. That guy says 95. Oof. It's not that bad here today, thankfully. But yeah, this idea of things changing, guys, and that's not happening. You come back a year from now, everybody's going to be in their same spots doing their same jobs. I mean, that is the nature of the business. So, all right, let me see here. Let's see who Andrew Burkhardt's watching. She's not watching anything either. Okay, that works. It's only 113 here in Phoenix. Hi, Dolly. How you doing? What's up, all you green devils? Yes. Karen needs to move to another state. No, I don't think she should. Nick Dev, can she sue the PD? Nope. They have governmental immunity. And besides, they could say, whoops, I guess we got it wrong. Remember, the process is the punishment. So they sucked her bank accounts dry, drug her name through the mud, and made her worry away years of her life. Oh well. They get to go. and walk away. Laura Lee says they're finished closing tomorrow. Tomorrow closing arguments. Yes, but we're gonna see what the charging is ultimately, because we are gonna take a look at that and see what happens. Because there might be some more stuff that's going down. We just haven't gotten to that point yet. So it's been a very interesting trial. Karen's had the ability to fight back, but think if this was the average defendant having to fight against this, it's something for you to think about that Karen would be kind of SOL. There weren't people out there fighting on her behalf. Karen, a lot of people are SOL in this situation. So something to think about. Something to think about. You know, she could recoup some of that money via book deal. Oh, certainly she can. But the issue is she going to get a book deal? Is someone going to hire her? You've got to get all those steps first. And then we'll go from there. Okay. Hold on. Yeah, hold on here, guys, real quick. Sure can. Okay. Oh, it just popped. It just dropped. Okay. All right. How would I have killed John is the new book coming out? Yes. Oh, I would have done it. The feds don't ever help you, except in this case, it looks like they did. POV says, what do you make of the feds being involved? Seems like a lot of effort. Was the department under investigation or something? I think that this was so crooked and so confusing. The feds got involved just to make sure nothing bad was going on. And it clearly doesn't look like that, but at the time, yeah, this looked really, really bad. So made sense for them to be wanting in there and doing it. Um, so me. So I think Andrea said Karen Reed will sue for civil rights violations. Remember, you're gonna have to beat qualified immunity. And these cops being incompetent, it's one thing to say they're incompetent, but it's another to accuse them, because being incompetent is not a civil rights violation. Them sucking at their jobs is not a civil rights violation. Them bastardizing this case, yes, could be a civil rights violation. Intentionally hiding evidence, but you're going to have to prove they did that, and I don't think you can. So I hope that makes sense. Like, you could say, "Oh, I want to, make them pay." It's like, but you're not going to be able to make them pay. The city ain't going to fucking settle with her. So, I mean, that's the thing. I don't know what she's going to get out of this, and I would argue pretty much nothing. Yes, My Struggle by Karen Reed. There's evidence of more of the corruption. Yes. Yes, I agree. But once again, you're kind of like proving a case like that is hard to do even when you've got all the evidence on your side. So, I mean, think about all the like qualified immunity, especially like they're in like the Fourth Circuit, I think, or Second Circuit. God, I don't think they'll overturn it. I don't think they'll overturn the case. I don't think they'll send something. I think they'll uphold qualified immunity even in a situation like this. Absent everybody admitting like, ha 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 ha, ha yes, I intentionally lied. I mean, that's the big thing there, guys. She can do a lot of stuff. Is it gonna matter? Okay. God, we gotta use law and cuck. Oh my god. They're they're back in session. So here we go. So here we are. So, oh, Karen's going up. Karen's like, I want to hear this. I want that. Truth Finder, 50% off confidential background reports. Those reports will not be admissible for purposes of the Fair Credit Reporting Act or in any legal situation. Did not catch the first period. Did Lally continue his threat of perjury scheme? Yeah, kind of. He kind of. So, is she allowed to go up? Well, I mean, they waved her up there probably. So, it must have involved her. So, we're sitting here waiting, just waiting. So, we're just waiting. We're just waiting. Why has this guy got a vocal on his shirt? Put whatever you sell instead of the animated ad. I don't have anything to sell. Oh, I know what I need to put my. Uh, we'll cover it up that way. How about that, chat? We'll cover it up the best we can. DNA piece reviews are funny. Yeah, they are. But even Turtle Boy's done in there, and I'm surprised. Or maybe he's out hanging out with everybody. No one from Karen's side is in yet. They might. Don't know. Don't know what they're up to. So here we go. Yeah, here they go. People are starting to filter in. I think nobody was in a rush. No one was in a rush.
You are unmuted.
All right. So the charge conference, the first question I have is regarding I'll go through them in the order that I have them in my very rough draft. But there's no request of the lesser included offense of voluntary manslaughter to the second degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter as a lesser included of the second
I'm
degree
surprised
murder?
they're not.
I'm sorry.
Wow. I thought they'd go for it.
That's correct, Ron.
Okay. And neither side has requested an instruction of a lesser included of OUI?
It's correct as well.
And the defense is not requesting that?
That's correct.
Wow.
Okay. All right. So.
Huh.
All right. So the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions.
Oh,
So
geez,
aside
that's
from
a
that,
horrible
the
way of
first
doing it,
instruction is
Bev.
presumption of
Please
innocence.
don't.
I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy.
Okay.
Then I do the view. I should say right
We'll
off
get
the
to
bat,
this in a
I
second.
am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and we'll do each one. The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
I'm sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour.
What was the beep?
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one too by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct
Well-
and indirect, and circumstantial evidence. So I received today
Normal.
defendant's request, a late request for the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the
Well-
language from the case law here that you've cited. There,
I actually quoted it, Your Honor.
so from which one? From Haunch or?
Hodge quotes McCormick, and McCormick takes the law from Dustin. There are
Yeah, so
multiple cases that.
right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. That's,
Prefer that.
I haven't given that in years, but I'll give that part of it. And just to finish off that paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that.
Mhm.
All right.
So,
All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe, the second element, first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has three sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes, ma'am.
Okay, so I am going to put that in there. All right. And the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor, with us.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Oh, do you want to just leave the whole generic sentence?
I think we can, yes.
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but there's no evidence of drugs either, so do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Ms. Giannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but
I would prefer just to keep it in and just jump it as
all right, so I will think about this one tonight, okay? Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Ms. Giannetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element? Yeah.
Like I said, guys, it's like paint drying. I warned you.
Is there a page number on what's going through my?
9.
I have it, yes.
All
Sorry.
right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion of it, I thought was from the model instructions. If I'm wrong, then we're fine with model instructions on this issue.
All right, what does the Commonwealth say?
The Commonwealth's language comes from the model and jury instructions, I believe, from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read?
On page 5, third paragraph, it's either a similar sentence or a
Yeah, it's a similar sentence, and I was just having both. It was, a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected or emergencies. So we don't need both, Ms. Giannetti.
I agree.
So you had both, so I'm just not going to do that,
We're perfectly fine with
okay? So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless. So for the fourth element, Ms. Giannetti, this is where your language. You have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms. Mc?
No, yeah. Yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
yes.
Okay. All right. So I'll keep it. I mean, it belongs under 4. I'll keep it at 4 and not have it at
Yes.
5 where you put it, Ms. Giannetti, okay? All right. I am going to give the lesser included offense of involuntary manslaughter. So there's additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those two sentences I find go better together. Ms. Giannetti, is there any objection to that?
No, I understand the question.
Okay, any objection from the Commonwealth? So, Ms. Giannetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So,
I think you're right.
so okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay.
Correct. The state did not offer witnesses in rebuttal.
In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth, if you could consider it, please.
Yep, so that will be in that last paragraph of that offense, Mr. Minetti. Okay, then the lesser included offense, motor vehicle homicide, felony OUI, liquor, and negligence. I'm going to give that. So I don't have anything because you didn't, the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Giannetti. I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. It's obviously the law, right?
Right, that's the law of negligence, and I do understand the law of negligence.
Okay.
Right.
All right, thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident. So, Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, so they don't need further instruction.
Yeah.
I think it would be sort of redundant or unnecessary to explain to a juror what failure to provide documentation of registration and things like that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Giannetti?
We're in complete agreement, maybe for the first time in this.
All right, so we'll just leave it. You've offered 2 pages or 3 pages of definitions, so we won't do that.
It's fine.
Okay. All right. Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law. Tell me about your request to have that.
Your Honor, the request goes to the defendant's state of mind. Also, it would go to any intent or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If they understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon, and in using that to strike an individual, that could be used in their deliberations, assessing the defendant's intent or state of mind at the time of the collision.
It seems to make sense, Ms. Tianetti.
My position is it's unnecessary, but I'm going to waive argument beyond that.
Okay, all right, I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears on the Commonwealth's request.
Huh.
All right, so that's basically it. The longest part maybe is the general instructions in the beginning. Anything specific from the Commonwealth that I did not include?
Do you intend to give a conscience of guilt instruction?
Oh, I'll hear you on that. I don't, but you can try and convince me if you want.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to a consciousness of guilt. There's an inference that the defendant deleted portions of the Ring video, a narrow area of Ring video portion.
There's an allegation, you never proved it.
They begin with Mike Camerano picking up his daughter at 11 a.m. They resume at 5:07 when the defendant.
You never
backs the vehicle
demonstrated
into
it.
John O'Keefe's.
It's a fact,
Then
not an
there's a period
evidence.
missing where the defendant shows the broken taillight to Jennifer McCabe and Kerry Roberts, and then the video resumes again when the victim's niece gets picked up. But not only the missing Ring videos, but also the defendant's behavior. What began as testified to from the Dighton police officer, the defendant's father called the Dighton Police Department and requested a ride to the Good Samaritan Hospital due to the weather conditions. He then drove himself to Brockton to pick up the defendant and perhaps bring her home. What they do in the middle of a blizzard is now Dighton to Brockton is half a distance. Then they travel further all the way back to Canton to retrieve the murder weapon. Along with the defendant's brother, they all meet at the victim's residence to remove the murder vehicle and bring it all the way down to Dighton, Massachusetts. That would go to concealing evidence and intentional. There's also evidence of the defendant's statements going to her.
None of this was ever covered.
Hours after John's death.
You can't do
That
this.
the victim's sister-in-law calls the defendant, reaches out, wants to make
What
sure
the
she's
hell?
okay. The defendant says to her, I only have to remember the bad times. You'll likely never hear from me again. Aaron O'Keefe testified that she tells the defendant, of course we are, we're friends. She's never heard from the defendant since. So I think that goes to the defendant's state of mind in the hours after the death. But in addition to the Ring video, I think there's strong evidence of consciousness of guilt to move the murder vehicle within hours of John's death.
That's such
Tianetti?
bullshit.
Well, first of all, with regard to the Ring video, Trooper Guarino, who was certainly no friend of the defense in this case, testified that there was zero evidence that Karen Reed had access or had access anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. So I would say that that is a red herring. This is the one case, I think, a very rare case where there's much more consciousness of guilt evidence with regard to the Commonwealth's own witnesses than there is with regard to the defendant in the criminal case. With regard to the other arguments, I'm having trouble following.
So the moving the car extra distance during a blizzard.
Yeah, but that was never
that part of
proven.
the argument that the Commonwealth made.
When the fuck did that ever come in?
The evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time
Yeah.
there. To say that moving her car to her own home where the police later found it because she was there and picked up the phone and said that the police were coming and she stayed there and they were able to seize the car, that does not rise to the level of consciousness of guilt.
Okay.
Kind of the defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support an inference that she was concealing evidence.
But, well, even if it's her parents' house, Your Honor, again, if she's no longer dating John O'Keefe because he's passed away, then, you know, it makes sense for her to have her vehicle at her parents' house or her own house. Again, it's not rise to the level of consciousness.
Nor does she stay at the home of her boyfriend to grieve with the family who just lost John. She quickly comes back to the house, brings her family members, goes upstairs for about 20 minutes by herself with her father, and quickly leaves the residence.
I don't think that was ever established on the record.
Upstairs, or that she had access or the ability to change anything.
Okay, it's a little bit more robust argument than I expected from the Commonwealth, so I'm going to think about this. I'll let you know before closing argument tomorrow, and if I don't instruct on it, Commonwealth's still able to testify to it.
What? That didn't happen.
Witness pretrial preparation.
Whoa. I don't even recall that part coming out that way. I don't ever remember that part. What the hell? It's a fact, not an evidence. Yeah, why wasn't this brought up during the trial?
That came out on both sides. I'm going to give the second alternative. Okay, Ms. Giannetti, I'll hear you on your instructions.
So I believe that we covered the vast majority of it. Your Honor.
I'll give you the opportunity to argue the Bowden one,
Oh,
just so you can make a record.
sure. All right, let me just pull up. Just have a moment, sir. I put that document away. That's the good thing.
I'll find your page.
Okay, so, yeah, I mean, with regards to the Bowden evidence for instruction, Your Honor, you know, having done this for as long as I have, it's requested a lot and not given, you know, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this is Bowden argument.
Right.
But, you know, I think that if there's any case where Bowden instruction should be given, it's this one. You know, we start with the conflict of interest that existed at the start of this case, and the fact that Michael Clarkman was allowed to not only continue with the case, but to be the lead investigator or police officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then move to the fact that, you know, he never, as a lead investigator, went into the house at 34 Fairview. He never looked around. He never checked for any signs of struggle. He never checked out the basement. He never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. He never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's mind. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed together, that they were not separated out on numerous occasions. Brian Albert, Paul Albert, John McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Julie Albert were interviewed together. And then we have all this, you know, evidence, the way it was handled, or I should say, mishandled. You know, starting with the leaf blowers and the solo cups and things being pictured on the floor of garages, but not being properly handled, and the fact that there are no chain of custody laws for the evidence before March of 2022. So
Yes, there are.
I just highlight those, Your Honor, as examples. I believe there's more, but that's the record that I would make.
Okay, so you satisfied you've made a complete record on this?
I mean, so.
All right, but I did include some specific bias language that I read to you early on that sort of ties into this. Okay, so nothing else?
So I have one question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or
Yeah.
not.
Thank you for bringing that up, Ms.
I
McLaughlin.
agree that it's not appropriate.
Okay. All right, so I will see you tomorrow morning.
Question, Your Honor, is that, and I haven't tried this book before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. All right, I do give 2, maybe 3 copies to the jury afterwards.
There was some question as to the use of chalks for closing argument.
To permit the use of chalks for closing argument?
So can we focus on this? So does the defense intend to use chalks?
I'm going to refer myself also on that. 2.
What do you intend to use?
Photographs of the vehicle and photographs of the taillight.
Good.
2 side-by-side photographs of the taillight that are in evidence, and photographs of the vehicle, still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it. for me.
Okay. Commonwealth have any objection?
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events from January 28th through January 29th.
Okay. Any,
The request is I'd like to see that.
sure, you should both exchange them, okay?
Judge, my other question is that at one point during the trial, there was a changing of 2 jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number. They may not remember what that is.
No, I have
No,
absolutely.
they may not.
Yeah.
They may not know their old juror number.
Yeah, they might
Their
not.
actual 3-digit number.
Right.
They're
they
not
may
going to
know
remember that.
Do you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay.
All right. Why did you want to move them into, we'll talk about this.
Okay.
There's no way they remember that now.
At the, at the end
There's
of
no
the
way they
instruction,
remember that.
before I give the instruction on be fair, the SJC instruction on be fair.
Can I ask a question?
Yes,
You pick a full person?
yes. Yeah,
So sometimes it's done by lottery. I just want to.
no, so, right. In Massachusetts, it's supposed to be chosen by the judge. So I know. All right. Anything
I
else?
need to learn more about Massachusetts law.
Yeah. All right. Thank you. We'll see you tomorrow. Jim.
Board, all rise.
So, that's it, chat. We're done. And now the juror number thing they're talking about, like when they first got in there, their juror number 001 through 00 like 900. Well, he's like, oh, we'll pick it based on that. And she's like, they don't remember their. I'll give Judge Bev credit. There's no way in hell those people remember their fucking numbers. So it seems short but not sweet. Yeah, but that's what those are. They're really quick. They are rough and tumble. We got some questions to get through here. Karen just got a freaking gift. Well, she kind of did, except she's already facing a lesser included as part of her charges. So, one less is better. The Chugi Show, how you doing? It's saying, not been this nervous for a ruling since Kyle Rittenhouse. I can understand that. Brooks says, do we eat lead paint chips? I mean, probably. Snake is saying, wait, there was no state rebuttal? That is correct. The state did not present rebuttal evidence. Take Evie says, come on the impact of the defendant going before a prosecutor. I thought it was prosecutor, defendant, and prosecutor to close the court. Yeah, that's the typical way, but they would make the argument that Lally has the burden of persuasion, so he gets to go regardless of the end anyway. 10K says, allowing the DA bringing general statements in closing not introduced during trial grounds for appeal. Yes, I would argue it's a fact, not an evidence. Like that whole story, I don't think I've ever heard any witness actually explain it, what they did. So, no, I would argue that's not a applicable issue. Or I'd argue that is an appealable issue. She called upon her friends to be witness for an alibi, yeah. And then Skies and Neighborhood says, where do you get language instructions to argue jury instructions? Well, here you go. Every state has jury instructions. And you can, let me see, wait, did I miss it? Oh, here we are. So jury instructions, like in Ohio, there's a similar place you can find them. It's called the Ohio Jury Instructions. The Supreme Court works on proposing these and putting them together. Um, and what do they do with them? Well, in this situation, let's look at some of these instructions. So, instructions before and during trial, general final instructions. Okay. So, general final instructions include the function of the judge. And this is literally the beginning of it all. So, this is, and then you follow stuff and put it together and start talking from there. Jury instructions are absolutely boring to sit there and read through, but you have to do it. Make all the proper arguments. It happens. So those are the jury instructions, and they tack on and add on to them. Like one judge I'm in front of, they already have it as like a word program, and you put in like with highlights. Here's the stuff I'm changing, adding, or deleting, and then the other side does it, and you see the judge kind of works out a little bit of a, gives you a little bit of what you're looking for and they're looking for, or may just deny you completely. Sean needs some sativa. Yeah, no, I don't. But so you guys understand, these are what the jury instructions are. They are put together in that manner. Sorry, guys. I fucking talked to myself for a couple of minutes. No, I was talking to myself for a couple of minutes there. Sorry. Yeah, no, the charging instructions, that was pretty normal, except for that last little bit at the end about um the facts not in evidence. So do we still get breakfast and a clean set of clothes? Well, you might. I don't know. You sounds like you need a bump. Yeah. So anyway, chat, that's where we are. It's all done. They are going to start up in the morning, and we'll find out from there what happens. I will not be available tomorrow till late in the afternoon, just because I've got stuff to do, and we'll go from there. So, we've got two people who said the jury will be back tomorrow. I kind of hope the jury is back tomorrow. They deserve it. Karen Reed deserves it, and like get it done. So. Alec Baldwin. Yeah, Alec Baldwin has started. We might switch over to that in a second. I need to set that up. Hold on, let me. Yeah, we are going to work on that. We'll do Baldwin next. We'll get Baldwin going here, guys. Hold on one second. Um, Oh, it's scheduled for 4:30, so we got some time, chat. We got a lot of time. So, yeah, I think let's see if there's any updates out on Twitter. If there's any people acting like spazzes out there in front of the courthouse, see if anything happened. Oh, so there's footage of Karen leaving court. The Dirty Cowboy trial. Who's that? What'd you think of the experts today? They were really they were amazing. Absolutely amazing. They're the type of things you want out of an expert. Not some rum dum who says, oh, well, I worked for like 10 minutes. You know, these guys were good. But anyways, here's Karen Reed. So that was a brief bit of Karen there.
Type of an analysis. You could go through and do it. Sure. Yeah.
And you didn't do it, right?
No, I did not do it. No, because there's no need in this case. We don't know what happened in this case. There's no indication of, certainly it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there. And then the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided. Isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
When was it that you looked at this additional material and who provided it to you?
We were informed after a report was issued that DNA was found. And that was really the primary issue. I believe that some DNA was found on the housing, which, again, there's numerous explanations or ways that DNA can get on a light housing.
Let me ask you this, sir. With regard to the materials that you were provided with, was there anything in there that stated that Mr. O'Keefe's skull fracture on the back of his head was caused by contact with the tail light?
No, I don't believe there was anything in those materials that stated
Is there
that.
anything in those materials that indicated or that anyone stated at any point in time that Mr. O'Keefe's arm was outstretched at the time that he was struck by the vehicle?
No, sir, there wasn't.
Was there anything in there indicating that his arm was tucked in at the time that he was struck by the vehicle?
You know, there's no indication in any of that evidence of what he may or may not have been doing, how he may or may not have been positioned. I mean, that's the whole issue. There's no evidence to indicate what may have allegedly occurred in this case.
I mean, that's a very good summation of what
Being
happened
done
there.
By you, is that correct?
Then this is interesting. Turtle Boy put this up from Court TV. You know, that earlier today, the ARCA doctors were given, like, everybody believes them. And that it looks like 2 people were charged. So let's see. So. Anyway, so. Huh. I thought I heard that through my fucking headphones. I thought I was on here. It's driving me crazy. So the police broke up a fight outside there, and what did they find out? Well, they determined that 2 Canton residents were charged with assault. Jillian Daniels and James Ferris. So as a result of that fight, 2 people were charged with assault from all of this, and 2 Canton residents were charged with assault. So Jill Daniels and James Ferris. Couldn't happen to nicer people, huh, chat? Let's see what else has happened. Let's see what else has happened. Let's see what Turtle Boy's got any new updates. Yeah, no, I think we're all set. I think we're all set. There is nothing else, chat. I'm just double checking here. So. So yeah, I think we're all set. When I got ice cream for chat, you feel neglected. Well, that's okay. Lois says, who are these people in the case? Remember the Daniels family? Those are people that are friends that allied with the Alberts. So that's who they are. Does it help his witness intimidation case? Oh, yeah, it does. Because if people are like, oh, we're scared of him. But like, oh, we can't handle it. As soon as he shows up, you're like, oh, fuck you. I'll kill you. Like, well, you're not scared of that guy. So there is no ice cream. Yeah, sorry, guys. The ice cream truck went by too fast. Yes, guys, we are doing locals at 8:30. If you guys don't know what locals is basically kind of like Patreon. So potentiallycriminal.locals.com. You could join us. We hang out. We do a live show starting at 8:30. Can I talk about all kinds of fun stuff we couldn't get to today? Stuff not appropriate for here as well. Yeah, and I hope to see you guys there. If you guys aren't sure if you want to subscribe, you can use the free promo code BoogerSugar to get 1 month free. So, yeah. That's it, guys. We are all caught up. We will do Alec Baldwin at 4:30, but that's about an hour away. Nothing else to do until that happens. And Shugi tries to make sure I cover this. Not been this nervous. It's Cal Rittenhouse. I'm up there with it. I'm very worried for Karen that she is going to be in trouble. So, here's hoping against hope. And yeah, guys, we're all set. So I will see you guys in about a half hour. We will get started with that. 253 people here on YouTube. Thanks, guys. Please like, share, subscribe. I'd appreciate it. And yeah, until next time, Karen Reed is not guilty. In fact, she's innocent, which is even scarier. So, good night, everybody. And like I said, I'll see you at 8:30 on Locals.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick hated yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potentially Criminal Show.
Bella, we're going to do Alec. It's at 4:30. It's a whole hour away. I got some other things I got to do. We will do Alec Baldwin later. Like I said, we are going to do Alec Baldwin, just 4:30. So we got a whole hour. I'll see you guys then.